All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is Airbnb versus Doe. Counsel?
Thank you, Your Honor. My name is Joel Perwin. I'm counsel for Airbnb. Just as a preliminary, when somebody wants to register on the Airbnb website as a host or a guest, he has to fill out a form, and he has to click a box that constitutes his agreement to abide by Airbnb's terms of service. Red box right next to it, terms of service. He clicks on it. Terms of service begin with all capital letters. Read these terms of service. Your legal rights and remedies are limited, and if you scroll down, you get to a provision that says dispute resolution. Any dispute, binding arbitration, waive the right to trial by jury, arbitration rules, not just general, but in accordance with the AAA, commercial arbitration rules and supplementary procedures for consumer-related disputes.
On that point, am I correct in understanding that in this electronic format, the person who's signing up can actually click on a link that will take them to those rules?
Exactly. That's the red button. Click on the link. You could throw it all on that front page, but there's a lot of general categories there, and it's a couple pages long. So it's more discreet and I think more comprehensible if you link it to the terms of service. And as I said, the big capital letters say, read this, it limits your rights. You get in there, it says AAA rules, it identifies the rules, gives you the phone number, gives you the website, and contrary to what you've been told, you don't have to go find it. You don't have to go look for it. There's a hyperlink to it, which means you click on it and you're right into them. Once again, you could dump the AAA rules into the terms of service, but they're long. They're page after page.
Well, but counsel, I mean, if the standard is clear and unmistakable, short of linking to or reproducing all of the FAA rules, or AAA rules, I'm sorry, couldn't they just have said all disputes, including the arbitrability of this, shall be decided by the arbitrator? I mean, it would seem to me like those additional 5 or 6 words would have made unmistakable, which I think is the standard, the desire here. What's your response to that?
Okay, well, they do say that, and the question is where they say it. So you link to the terms of service. Terms of service link to the AA rules. You click on them, and they say, the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement or the arbitrability of any claim or counterclaim.
I concur that that's in the rules. I guess my question to you is, you agree that you'd have a stronger case if the agreement in its plain language on its face just said the same thing, right?
Question is on its face where? On its face on the opening page where you're just putting general rubrics? You're going to throw in 3 pages there? On its face on the terms and service where you have a whole list of terms and service? You're going to throw in all of the AAA rules there? You're going to pull some out and just list them there? Or you're going to say where they are?
He's asking you, why not just put in 5 or 6 words, not 3 pages, not the entire rules, none of that. Just 3 or 4, 5, 6, 7 words that basically say the arbitrator is going to decide whether he or she gets the case or not to begin with. I mean, that's kind of important now. People are waiving their right to a jury trial. In my world, that's still important.
Very important.
So why not put that in there?
They could put it in there. They certainly put it in there. The question is whether it's clear and unmistakable the way they do it. There are lots of other provisions in the terms of service and lots of other provisions in the arbitration rules that are really important. They could grab them out, and they could do that too. They could isolate them. But instead, and it's been approved by virtually every court to address the issue, the age of the internet, they give you a discrete linkage, and then it's highlighted. Read this, get to it, dispute resolution. And that's the way it's written. How it could have been written respectfully.
Well, am I correct in understanding that this is, your position is essentially the way this is set up electronically is like having those rules as a physical attachment to a paper document. It's like, it would be like see Exhibit A, and then you can go back at the back and look at Exhibit A with the rules. I don't see how, in principle, this is any different from a physical document, a paper document that would be like that.
I agree, that's what the cases say, and I think that's better. I think it's better if you link to it and say, here it is, than if you dump it in there. Now,
But counsel, sorry to interrupt you, but putting that aside, I mean, wouldn't we be essentially acting in more of a sort of legislative capacity if we took it upon ourselves to kind of think about what would the best way of conveying the information be, and if it didn't meet that test, we would say it's not clear and unmistakable? I mean, don't we need to just look at the contract and the attachments together that were presented to the consumer and just ask, does this language do the trick? I mean, isn't that the question for us?
I think so. I think what we're looking at is what they do say. I understand what they could have said. It might have been better. It might have been worse. But look at what the overwhelming, unanimous cases to address this say. They're looking at this language. They're looking at language of contracts that don't have a hyperlink the way we do. And they say, we got 3 other district courts of Florida, including the 4th District in its latest decision that we talked to you about. We've got virtually every 11th Circuit decision to look at the issue, same language, including this recent overdraft decision, which came out in the reply brief. We have the other federal decisions. We have the other state court decisions. They all involve linkages, not a hyperlink to the AAA rules. They just identify them, and they say that's enough because they're clear. And in contrast, we've been given cases by our opposition that don't have hyperlinks and whose language can only reinforce our position because it's so clearly inadequate. Like this Burlington case from Texas they cite, where the authority to the arbitrator is specifically withheld, quote, including the question of arbitrability, withheld from the arbitrator. And I went through every other case they cited. They all contrast so dramatically from this language that we used and all the cases that support it. Now, there were 5 rationales that the district court gave. The first 3 basically say, unless you throw it in there, it's no good. Every case has rejected that. Terms of service themselves are silent, they link. The AAA rules are not attached, they're linked. Terms of service are simply referenced, but not the question of arbitrability. If the court's going to adopt that position, that's about as radical as you can get. That departs from every case that's ever decided this issue. So let me talk about the two rationales of the district court that are a little more different. Both have been rejected by every court but one on the latter to address it. And I think they don't preclude a conclusion that this language is clear and unambiguous. One, that the terms of service themselves reference the AAA rules as to how the arbitration is to be administered. And the argument says, oh, well, that only kicks in if you've decided that the arbitrator is going to decide arbitrability. And then these rules determine how he administers it. We say, and the cases say, that's not a reasonable interpretation. If that were a reasonable interpretation, then when a court decides jurisdiction or venue or forum nonconvenience, it's not administering the lawsuit because that's a preliminary question, and that may kick it to another tribunal like this would. Of course, that's the administration of the lawsuit, and that's the administration of the arbitration. It's everything that an arbitrator decides, and the word administered, as all the cases say, covers everything, including the arbitrator's resolution of the issue of arbitrability. So the last point that the district court made was that the arbitration rule says that the arbitrator has the power to decide the issue of arbitrability. And the suggestion we get from our opponents is, well, it doesn't say that the court does not have a concurrent power. It just says the arbitrator has the power. Well, every case to decide the issue has also disagreed with that. Well, I think that one exception. And that is that it says the power. The arbitrator is given the power. And we suggested, and there's a case right on point that suggested, Blanton out of the Sixth Circuit, how do you administer a regime in which both the court and the arbitrator have the power? Well, how do you do it? The plaintiff runs to court and says, you have the power. And the other party runs to court and says to the arbitrator, you have the power. It's a race to the courthouse. That's what this Sixth Circuit court said in a case called Blanton. It said you can't administer something like this. Whoever runs to court first is gonna win if there's concurrent jurisdiction. It's got to mean what it says, the power, and that's what the cases say. We've not heard a response to that particular argument.
Counsel, so one of the other things that Judge Thapar said in the Blanton case is that the parties contract in the shadow of the law. And so this contract was entered into in 2016. It seems to me that this principle of this language being deemed clear and unmistakable was pretty well established by then. I mean, at what point does it sort of cease to be something that we look at sort of in the abstract as if we're writing on a clean slate versus this is just something that, you know, are the parties expected to understand that all these courts have said for years at this point that this is deemed clear and unmistakable language? Is that is it right? Was Judge Thapar right that that's part of how we should be looking at this?
Respectfully, Judge, I think my opponent would say that the parties are not required to read the case law, and I don't think they are, and I would never suggest that. And I would agree with him on that. But they are required to read the language, and the body of case law, virtually unanimous body of case law, tells you, I respectfully submit, obviously this court's going to make its own decision. I would never suggest that it's going to rubber stamp other cases, nor have any other decisions on this issue. But what I'm suggesting is this overwhelming weight of authority which has established this as the clear weight of the law in this area informs the question of whether this language is clear and unambiguous. It is part of the lexicon. It is an accepted rubric under which to conclude that the language is clear and unambiguous. And independent of all those cases, it is. It is. You can't dump the AAA rules all into the website. Even with a piece of paper, Judge, you'd have it as an attachment. You can't dump all the AAA rules into the terms of service, page after page after page. Even there, it would, if on paper, it would be an attachment. Let me go back to the rationales. We've gotten one more argument that our opponents made, and that is that the rule should somehow be different if the people who are executing the contract aren't quote-unquote sophisticated. We say first, you introduce no evidence that you're not sophisticated. You may be very sophisticated people who want to rent an Airbnb. They said, well, that's your burden. Wrong. It's our burden to show that there's a valid arbitration provision, which was never denied, and this is all in the standard of review. It's their burden to show that the issue was not arbitrable because of sophistication or for any other reason. There is no record on that point. That's the end of it. Second, on the merits, the cases are overwhelming that the sophistication of the parties is not a factor. If you're applying an objective test, which is this ambiguous or not, how are you going to factor in some subjective consideration of the sophistication of the parties? Where does that work in? How does it fit in? And the answer is it doesn't. The sophistication of parties is not relevant to the question of whether contractual language is clear and unambiguous. Everybody is supposed to be able to read it if it's clear and unambiguous. And respectfully, once again, the overwhelming majority of cases say that. This new 11th Circuit case involved unsophisticated parties who had bank accounts. And the 11th Circuit says, we've said over and over that sophistication is not a factor. We've cited a plethora of decisions. Last point. We've said that even if the court decides that this is a question for the court and not for the arbitrator, this is clear and unambiguous. This court can decide it for itself, de novo. I don't want you to. I don't think that's the right way to go here. That's not what I prefer. But if you look at this, this language as against the allegations that are made by the Does in their complaint, it is certainly related to and arises out of the arbitration agreement, the agreement with Airbnb. You don't even have these claims unless you sign that agreement. You're relying on the terms of service, which are part of that agreement. We've given you a whole row of cases on that, and I respectfully submit the briefs on that. I don't think that's a close question, but I don't think that's where the court respectfully should come out. I think this language is clear and unambiguous as a matter of law, and I think this court, making its own decision, should join the overwhelming majority, if not unanimity, of other courts in finding this to the same effect. Thank you.
Counsel?
Good morning, Your Honors. May it please the court, Tom Sider with Brannick, Humphreys, and Berman for the respondents, Mr. and Mrs. Doe. Arbitration is supposed to be a matter of consent. The question here is whether the Does consented to have their claims sent to an arbitrator, and more specifically, whether they agreed to delegate the question of arbitrability to an arbitrator and away from a trial court. There is no clear and unmistakable evidence here to that effect, and that is the standard. What the United States Supreme Court held was, this question of arbitrability is rather arcane and difficult to understand, and so as a result, the law creates a presumption, and the presumption is that a trial court is going to make this decision in the place of an arbitrator.
Well, let's look at what's in the contract first.
Yes, sir.
That's determined as a matter of Florida law, is it not?
Yes, sir. Under Florida or federal law, the express language of the contract is what will control.
So what is within the contract itself, what composes the contract is a matter of Florida law?
Yes, sir.
All right, so when we reference the AAA rules, is that included as part of the contract under Florida law, as incorporated by reference?
It is incorporated, Your Honor, for the purposes specified in the agreement
Is
itself.
it part of the contract?
Yes, Your Honor, so long as the parties have an arbitrable claim that is being sent to arbitration. So, sorry.
Okay, but it's part of the contract, right?
So
your position is not that under Florida law, the AAA rules are not part of the contract. Your argument, as I understand it, is even though it's part of the contract, it doesn't suffice under the Federal Arbitration Act law to be clear and unmistakable under first options.
That is broadly our argument, Your Honor. I was trying to make a little bit more of a specific point, which is that incorporation is not an all or nothing proposition. There are circumstances under which you can incorporate a collateral document, but only if a certain set of events arises. So what the contract here says is the parties agree that they will arbitrate any claims within the scope of the agreement. Basically, they agree to arbitrate arbitrable claims. And then what it also says is that that the AAA rules will apply to any arbitration.
Well, it seems like if you have something is either part of the contract or not, you may have conditions precedent to the operative terms of the contract.
That maybe is a better way to put it, Your Honor. There are conditions precedent to the AAA rules coming into play here. And so when you synthesize those two provisions I was talking about, what you get is the parties agree that the AAA rules will apply to arbitrable claims. But there is no definitive answer or any answer at all provided in the agreement as to who's going to make that initial decision of arbitrability.
Well,
It seems like if you've got the actual terms of the contract include the AAA rules, right?
Yes, Your Honor.
And it's in there. It's incorporated by reference, therefore it's part of the contract. And then you look at the language, and the language seems to be pretty clear and unmistakable that the arbitrator is going to decide the arbitrability of any claim or counterclaim. So why is that not clear and unmistakable under the federal law?
Yes, Your Honor. So I would have two answers to that. And the first is that the Does would need to know that they need to look at those rules at all, and that the rules are not going to apply only in the event that the claims are sent to arbitration.
So they have to look at them for it to be operable as a matter of law?
They need to understand why the rules are being incorporated, Your Honor, and for what purpose. And so if they are told you only need to look at the rules to find out the procedural rules that are going to apply to a future arbitration
So
proceeding.
if I'm looking online at a real estate contract and it incorporates other documents as a matter of law, if the person executing the real estate contract, if they don't look at them, it's still not binding contract?
I think, Your Honor, if the collateral document does not end up becoming, if the condition precedent to the collateral document never ends up being satisfied, then they don't need to read it. Or, I guess put a different way, they only have to read that document for the purpose specified. So here, the Does need to read that document if they want to know how their arbitration is going to proceed, if they want to know what the filing fee is going to be, where it's going to be held, things like that. But what they don't need to know or intuit is that the threshold question of arbitrability is going to be answered by those procedural rules.
Where in the contract does it say any of this? Where in the contract does it say you only need to click this link if you're concerned about how your claim will be arbitrated? I mean, I guess this is a great argument if we imagine into the record and into the contract these limiting principles. The trouble with the argument is that, as I read it, none of this is in the contract, and when you click on the link, it says that the question of arbitrability will be decided by the arbitrator. Am I wrong about that?
You're not wrong about that, Your Honor. If somebody gets to Rule 7A of the arbitral rules, they will see that an arbitrator has the ability to decide questions of jurisdiction, and that includes arbitrability. I do want to focus on the language used there, because it does not say that an arbitrator will decide arbitrability. What it says is that an arbitrator shall have the power to decide arbitrability. In international arbitration circles, that's known as competence language. And what they say is it has a positive dimension, but not a negative one, meaning that it gives the power to an arbitrator to make this decision, but it's not supposed to displace the trial court's inherent authority to make that decision too. And I think that's doubly so here, where there is this presumption that a trial court is going to be the one to make the decision on arbitrability.
Are you saying then that a trial court interpreting that provision could correctly decide, notwithstanding the language, that the trial court, has the power to determine arbitrability?
Yes, sir.
Like let's say you're right, and this doesn't immediately foreclose the question. The question comes before a trial court of general jurisdiction, and the only language in the record is that the power shall be vested, or the arbitrator shall have the power. There's nothing else in the record. You're saying that, consistent with principles of general contract interpretation, a trial court could, without committing error, nonetheless say that it has power to determine arbitrability.
Yes, Your Honor.
Okay.
I think that...
Hum a few bars of that for me. Tell me how you get there.
Yes, sir. So shall have the power is actually a phrase that has been interpreted in a number of different contexts. The Constitution says that Congress shall have the power to levy taxes, but courts have held that doesn't mean that other governmental entities don't also have the power. And maybe a better analog is there are federal statutes that say that federal courts shall have jurisdiction over certain matters. And what the United States Supreme Court held was that does not displace the state court's presumptive jurisdiction over those same matters. So shall have the power is a phrase that has meaning in the case law, and the meaning is precisely what we've argued here. It is permissive but non-mandatory. And if Airbnb had wanted to make this mandatory, what they would have written is the arbitrator will decide questions of arbitrability. Shall have the power has a specific meaning, and what we know from some of the scholarship surrounding this is that the reason that this language was created in arbitration agreements is precisely so an arbitrator could have the non-exclusive ability to decide questions of arbitrability. And that is...
Can I simplify this maybe a little bit for me? I mean, it seems like it's clear that under first options, what we're trying to determine is what did the parties agree to, which is what you do in every contract case. Is that correct?
Yes, Your Honor, with the added caveat that it is not just a matter of whether the parties agree to something, but whether this specific
Whether there's clear
concept-
and unmistakable evidence as
Yes,
to
sir.
what they agreed to with respect to this specific issue.
Exactly
But it's
so.
still a basic contract interpretation. So you apply the basic rules, right? And that means that you would look at the whole agreement.
Yes, sir.
Okay. And it seems like the argument is in two sections. One is, does the language in the rules count?
Yes, sir.
And the first part of the argument seemed to focus on an argument that they just don't count at all for whatever reason. But you gotta, I mean, you look at the whole agreement, so you would agree that the rules count in determining what they agreed to.
Yeah, so Your Honor, what I was trying to argue before is that they are incorporated for this specific purpose. And I guess a broader point to make is even if the rules are...
Do they count or do they not count?
Yes, Your Honor, they do
Okay,
count. They count, and I think that...
So then the second part of the question is, does the language in the rules, is that clear and unmistakable evidence? And it seems like to me that, again, you go back to the principle that you look at the whole agreement. So you can't read that in isolation if there's, and you would go back to the first part of the page, the first part of the contract, the more conspicuous part, and it says, all disputes, the whole controversy is going to be arbitrated. So why wouldn't you, if there was any question, and I'm not conceding necessarily that there is, in looking at the rules themselves as to what's going to be arbitrated, why wouldn't you just look back at the other and say, well, any reasonable person reading this would be, it's clear and unmistakable that they agreed to arbitrate according to these rules, and these rules say this, and it just seems pretty straightforward.
Your Honor, so we do disagree that the rule itself, even if located, is clear and unmistakable in that it is permissive and non-mandatory. But I think there's also a problem of, the clear and unmistakable standard is not supposed to require these sort of inferential leaps. I mean, you're talking about cross-reference rules and tracking down this rule on jurisdiction, all to try to figure out a concept the United States Supreme Court has recognized as arcane and difficult to understand. And sort of the whole thrust of first options is people are going to overlook this concept. People don't know what arbitrability is in the first place. I didn't know what it was before I had this case.
Let me ask you this, because as you stated when you began, that arbitration is a question of consent.
Yes, sir.
And a party has to waive it, their right to a jury trial and consent to arbitration. So obviously it's an important decision that a party makes. And what I'm hearing here today is that the agreement, they can attach as many attachments as they want to online. You can have 100,000 pages. And in there, in a footnote someplace, they can say, oh, by the way, yeah, the arbitrator gets to decide whether this goes through arbitration or not. And that's okay, as long as it's in part of the package, as long as it's part of the text of the package. It's okay. And that's pretty much the law. If we go in that route, that's going to be the law of the land on everything. Online, just attach whatever you want to it, say these are appendixes, these are whatever, and it all counts. Isn't that what we're doing?
Yes, Your Honor, that's what Airbnb is asking this court to decide today, is that it all counts, so long as you put it somewhere in the agreement, no matter how buried it is, no matter how far away it might be from the actual arbitration provision itself.
Well, don't we have isn't part of our obligation in these cases, since arbitration is a question of consent, and before somebody waives it, that we make a decision as to whether or not the language was clear and unambiguous, so the person knew what he or she was waiving?
Yes, sir. I do think that's absolutely correct. That is a decision for this court. And looking at this contract here, just because, even if this court were to find the rule is clear and unambiguous, the placement of it is significant on its own. This is...
So first, you would agree that first options doesn't have a conspicuousness requirement. There's no requirement that this particular part of the agreement be placed in bold or highlighted or put on a front page or anything like that. It's simply whether, if you look at the whole agreement, it's clear and unmistakable that that's what they agreed to. That's what the contract says.
Your Honor, I would agree that first options doesn't say one way or the other, that the language needs to be conspicuous. And there, in fact, they weren't even interpreting contractual language. There was a question of intent as appearing at an arbitration proceeding. So there's nothing in first options that says how exactly the language needs to be portrayed in an agreement. We would argue that clear and unmistakable means express and explicit, and that there is nothing express or explicit about leaving this language out of the arbitration provision itself and burying it in this rule.
I don't see very much evidence in light of what Mr. Purwin said at the very outset of the argument that anything is really buried in this contract, right? You don't quarrel with the clear statements in the contract about how it affects people's rights, right? That's there. That's in the contract. And
Yes,
how Airbnb encourages the party, pretty like at the outset to read everything and advises the parties that there are things in the agreement that they need to pay attention to, right? That's over and above what first options would require.
Your Honor, yes, I would agree that it does direct the parties to read all of this carefully, and it does, in fact, incorporate an entire set of arbitral rules. But they can be read, and what Mr. Purwin is asking you to assume here is that somebody in the Doe's position can and will realistically be able to read 22 pages of terms and conditions and then 46 pages of AAA rules and pull out this concept
Isn't
of
his
arbitrability.
argument instead just that it's there? Isn't his argument just that it's in the contract? It isn't about what anyone's going to read or not read. His argument is about what's in the agreement, right?
Yes, Your Honor, and we can assume that they're going to read. It's that over the course of reading these 60-odd pages, is it going to be clear and unmistakable to the parties reading that they are delegating this question of arbitrability, or even that they are going to understand?
Well, it's in the rules. It's there. It's not buried. It's not in a footnote. It's there.
Yes, Your Honor, it's Rule 7A of the AAA rules. It is there. It's a fair distance away from the arbitration provision itself, and there is, of course, we would argue a reasonable possibility that somebody reading those rules would say, oh, well, this is just what happens once we get to arbitration. This isn't something that is going to affect the front-end question of whether we go to arbitration in the first place. This is just an issue that is going to come into play once we're already there.
And it's not even in a bizarre place. I mean, in the rules, it talks about what the arbitrator can, in fact, rule on. Its own jurisdiction, and including whether something's arbitrable or not. Those things seem to follow with each other, do they not?
They do follow with one another, Your Honor, and I think the question is, well, twofold. One, whether somebody reading that understands that this is something that's going to apply in the front end and not once they're already in front of an arbitrator in California or wherever it may be. And the second thing is whether they would read shall have the power as conferring a mandatory, exclusive power on the arbitrator to make that decision, which there's cases, and we've cited them in the briefs, that say shall have the power means something else. And so at the very least, what we have here is a reasonable interpretation of the language. Not just reasonable, but one that is supported by the case law. Shall have the power means a non-exclusive right to make a decision. Just like federal courts shall have the power to rule in their jurisdiction, it does not mean that trial courts, state courts, don't also have the power. And so once you get to a reasonable interpretation, for us, that makes the language ambiguous. And what first option says is ambiguous language, which is to say language subject to more than one reasonable interpretation, cannot, as a matter of law, confer the power on an arbitrator to decide arbitrability. That's sort of the point of first options, is that we have this presumption and that we're only going to read this express delegation from a contract if there is no possible way that somebody reading could reach that conclusion and not something else. And so that is, I think at the end of the day, what this boils down to. Is it clear and unmistakable? And also, I think a lot of what we've talked about today, mandatory versus permissive and incorporation by reference and administration as a jurisdictional concept, these are all things that are not going to be clear and unmistakable to most people entering into these contracts. Clear and unmistakable means explicit and express. And as some of the justices mentioned in the questioning earlier, it is not a very hard problem to fix. It requires a single sentence, and we're not saying the AAA rules need to be reprinted. There is an arbitration provision already in the terms of service here, and all we need is a sentence that says an arbitrator and not a trial court will decide questions of arbitrability. And once that sentence is there, Airbnb's problems are solved, at least as far as this case goes. It's not a difficult fix, and it's something that would explain the concept of arbitrability to somebody reading the actual arbitration provision. It is something that would satisfy the clear and unmistakable standard.
So, counsel, why is the case law so overwhelmingly against you?
Yes, Your Honor. So that, I think that there were early decisions that kind of underanalyzed and underdetermined this question of arbitrability, and they reached sort of I think we described as inertia in the briefs. There's kind of a terminal escape velocity, and then they couldn't pull it back. There isn't really any analysis in most of the cases. Up until really the Sixth Circuit's most recent decision, no one discusses at all how this language could be clear and unmistakable. And so, the analytical foundation of these cases really isn't there. And on the other side, we have the Second District's decision, which has been followed by the Fourth District, and we have the ALI restatement of international arbitration. They're not in the practice of disagreeing with every Federal Circuit Court of Appeal, but they did so here because they said this language simply is not clear and unmistakable. The rule itself does not give exclusive power to an arbitrator to make this decision. So it's true that we have all these federal circuits, and I think that Airbnb's main argument, I think as we heard today, is that this court should follow the federal circuits. But respectfully, it's the contract and the clear and unmistakable standard that should control here.
Isn't the whole context of this, though, that you're reading, if I'm the consumer, I'm reading this, and it's very obvious that the whole point of this is to take this out of the courts and put it into arbitration. And if I read the whole agreement, as Justice Lawson was saying, I'm going to see there that also questions of whether something will be arbitrated are going to be part of that. So this whole notion that just in the abstract, by saying that someone has the power, that doesn't necessarily mean that someone else doesn't also have the power. I understand that in some contexts that might be true, but if the context here is kind of an either-or context, and if I'm saying that, one of the two options has the power, I mean, isn't it kind of implicitly saying that I am intending to put that, make that the exclusive job of the one that I'm giving it to and not the other?
I don't think so, Your Honor, and I think that actually runs into the problem that first option discusses, which is parties may understand, okay, I'm agreeing to arbitrate all sorts of claims related to this agreement. But what they're not going to understand is that there is this threshold question of who decides arbitrability, and that's the arcane issue that parties are likely and frequently do overlook. And so that's why that needs to be spelled out differently than the rest of the arbitration terms, and that's what first options is trying to say. I don't know if I'm into my time here.
You're well over it.
Yes, sir.
But we helped you with that. You can, if you would, sum up in about 30 seconds.
Yes, Your Honor. So I think, again, I want to make the sort of big picture point here that what we need in this contract is clear and unmistakable language. And what we have instead is an arbitration provision that is silent on questions of arbitrability, a cross-reference set of arbitral rules that give only under certain circumstances a permissive and non-mandatory authority to an arbitrator to decide questions of arbitrability. That is not clear. That is not unmistakable. And so we would ask this court to approve the decision of the Second District. Thank you.
Rebuttal.
May it please the court, if I have the time, I want to get through 5 points. Number one, every case is decided on its own facts, and therefore, respectfully, Justice Labarga, we had a contract that had 6 different references, and each one was to 500 pages, and we had 25,000 pages. We may have a very different case. The court may decide it a very different way. That doesn't mean it can't decide the case this way based on these facts. Number two, Justice Polson, the issue is decided by federal law, not Florida law. Those cases are collected at page 17 because it's under the Federal Arbitration Act, federal statute.
Under first options, it talks about and makes clear that even what is in the contract, we look to state law principles to determine what's in the contract.
Respectfully, Judge, that is not correct. It says it has to be clear and unambiguous.
Well,
I don't see a reference to state law. This contract calls for the application of California law.
when deciding whether the parties agree to arbitrate a certain matter, including arbitrability, courts generally should apply ordinary state law principles that govern the formation of contracts.
Absolutely.
And then they go on to address whether or not this extra condition, whether clear and unmistakable evidence or not, whether the arbitrability should be decided by the court or the arbitrator is a separate component under the Federal Arbitration Act. Can we at least agree to that?
Yes, we can, and I agree state law principles are very relevant, but this is all under the adoption of federal law. I'm not going to fight about it because I think the standard is
So
essentially
you don't,
the same.
let me make sure I understand. Are you telling me that you think it's a matter of federal law, not Florida law, as to what constitutes the contract?
As to what is clear and unambiguous, which is why I've pointed to the Florida cases, because when the case is filed in Florida court, then it's deciding an issue of federal law, but it's not bound by anything but the U.S. Supreme Court. It can look at the federal cases as persuasive. Respectfully, it's just deciding an issue of federal law.
Well, that's why all those circuit court of appeal decisions that all go your way are important, right?
Well, they don't have to go my way just deciding federal law. They could have gone the other way, but
But
it
look,
happens
I mean,
they
this is
go
a-
my way because I'm right.
This is a helpful, the point is, when we're trying to decide what the contract is, he's saying that's a matter of state law. Whether, the test for what's clear and unmistakable, you're saying is a matter of federal law.
Yeah,
So you want the answer to be that the state law says that the whole thing is the contract.
Exactly. And I don't mean to fight about it because I don't think it's important.
Yeah, I don't think you want to fight with me about it.
I don't want to fight with you. I don't want to fight with you about anything, Judge. We go back a long way. Point three. The question respectfully is not, would these people or a given person understand this, a subjective test? The question is objective. Is it clear and unmistakable? That's the issue. And whether the Does would...
Hang on for a second. I mean, if we're talking about a contract dealing where whether Exxon Oil is going to put on a pipeline across land in states, and that contract's going to be this big, obviously the people who are going to review that contract are going to be sophisticated lawyers who are going to look at it with a magnifying glass, every single word of it. We're talking about basically John and Jane Smith checking into a hotel, and they.
No, we're not.
That's what we're talking about.
We don't know whether these are the most sophisticated people on the face of the earth. They may have rented these things 100 times. They may be commercial lawyers. We don't know. There's no evidence, and it was their burden of proof. These guys may be geniuses. We don't know. And in another case, if they made a record on that, I could deal with it. Now, I have on the merits given you a plethora of cases that say sophistication is not an issue because it's an objective test. Is it clear? Is it unequivocal? What do you do with the issue of sophistications in answering that question? You can't. It doesn't fit. You look at it and you decide, is it clear and unmistakable if the other side makes a record? And they did not do so. Point three. This whole need, I just did that. Point four, power. Arbitrators have the power. They have the power. I said, what happens? And the court in the Sixth Circuit case, the Blanton case, says, what happens if that's true? They run to the courthouse. Whoever gets there first is going to win. There's no way to administer that. The arbitrator has the power. And we cited the cases on identical language that if the arbitrator has the power, that is the power. In the federal cases, there is a supremacy clause. And if there's concurrent jurisdiction, the supremacy clause says the federal, if they're in conflict, if there's conflict jurisdiction, the supremacy clause, the federal rule governs. It tells you what happens if there's a conflict. It tells you how to resolve it. We got a conflict. Somebody runs to the arbitrator, somebody runs to the court. We don't know what to do. And respectfully, you don't interpret statutes or contracts to be absurd or respectfully unreasonable. And that is why all these courts have unanimously said that when you give arbitrators the power and say nothing about courts, provision never mentions courts, it means they have the power. Final, I'm through. The cases are clear. The judges didn't just reflexively follow some line of decisions and say, well, they said it and we're going to say it. Courts don't do that. Courts may sometimes per curiam affirm, they may sometimes write short opinions, but they make their own decisions, as this court is going to do as well. And there are decisions
Mr.
that have...
Perlin, I've let you go on an extra minute and a half. If you go ahead and sum up in about 30 seconds.
Okay, there are decisions we cited that go through this in great detail, and they decide this question in great detail. There is a reason that all of these courts are on one side of the issue,